We are into now the fourth session of the day. And this session deals with the role of the State Legal Services Authority under the new scheme. And for the execution of this particular topic, we have with us this afternoon Mr. Kanwal Arora, who is presently the Member Secretary, Delhi State Legal Services Authority. Mr. Arora came to the Delhi Judicial Service in the year 1992. And then Delhi Higher Judicial Service in the year 2006. He was also the Special Judge, CBI. But since the year 2019, he has been with the Delhi State Legal Services Authority. Therefore, he is the most competent person to share with us the role of the Delhi State Legal Services Authorities, what role it plays, and how it helps the scheme to be implemented, executed in an effective, speedier manner. In fact, the entire workshop today is focused on that the time which used to be consumed in these matters was too long. And now the procedure which has been worked out is such that the entire matter can be concluded within a span of 6 months to 1 year, which is something really appreciable in this entire process. May I now request Mr. Arora to share with us the role which the Delhi Legal Services Authority has played in this domain. Over to Mr. Arora.
Thank you so very much, sir, for your kind words. So far as I'm concerned, whatever we could achieve at Delhi State Legal Services Authority, so far as this particular aspect is concerned, that could be possible only because of the foresightedness and the vision of Honorable Miss Justice J.R. Midha. I must say that he has just revolutionized so far as this particular aspect, that is grant of claims and compensation to all those who are victims of motor accidents, so far as Delhi is concerned, and now it is being implemented throughout on pan-India basis. So first of all, I'll begin with congratulating the Chandigarh Judicial Academy for taking up this very sensitive topic and for collaborating all the stakeholders together so far as this workshop is concerned, because unless and until we work in a cohesive manner, it is absolutely not possible to execute the vision or the way forward which has been shown by Honorable Miss Justice J.R. Midha in this judgment of Rajesh Tyagi versus Jabir Singh. First aspect or first order of which was delivered in 2009. And prior to 2009, I must say that it is only those persons who were aware of their rights, that in case they had met with some sort of accident and have say lost life and their legal heirs, they are aware of this fact that they are entitled to some sort of compensation. Or if a person gets injured and he is aware that he is entitled to get compensation and files a petition before Motor Accident Claims Tribunal, only then he used to get the compensation for the injuries, for the loss suffered by that person. But after 2009, by virtue of the judgment passed by Honorable Miss Justice J.R. Midha, the whole process got revolutionized. He said and made it obligatory on the part of the investigating agency, that is Delhi Police to begin with, that they are not only supposed to investigate the crime from the point of view what CRPC says, but they have to file a detailed accident report. This is what Honorable Ms. Justice J.R. Midha said before the claims tribunal, so that irrespective of the fact that whether a person who has met with an accident is aware of his or her rights or not, he should get whatever his legitimate dues are. Uh, Even otherwise, all those persons who right now are working, all those officers who right now are working with state legal service authorities, either Punjab or Haryana legal services authorities, they are aware of this fact that apart from providing legal aid and assistance, we also owe an obligation as part and parcel of the legal service authorities to create awareness amongst masses, to tell to each and every person that he or she has a right to get compensation in case he or she somehow unfortunately meets with an accident. I must say that so far as our country is concerned, it has a dubious distinction of having the highest number of road accidents. According to the latest report of MORTH, that is Ministry of Road Transport and Highways, approximately 4,49,000 road accidents they were reported in the year 2019, which resulted in almost death of 1,51,000 persons, and it has resulted in causing injuries to 4,51,000 persons. And if we see the average on a road, every accident takes place every 1.17 minutes, and it results into death of a person every 3.47 minutes. So when such sort of high percentage of road accident takes place, it becomes the moral and constitutional and statutory obligation of all the law enforcement agencies, and we being part and parcel of those particular stakeholders, it becomes our duty to do our bit. And I must congratulate Justice Midha that the central government, whatever schemes, whatever points Justice Midha had taken up in his judgment of Rajesh Tyagi versus Jabir Singh, central government had taken note of this fact and made amendment in the Motor Vehicle Acts, which came into force with effect from 1st of April 2022. Similarly, central motor vehicle rules, they were also amended, and the same have come into force with effect from 1st of April 2022. For the first time, it has happened that from whatever observations were made in a judicial pronouncement, they have been incorporated in the statute. So automatically that again causes an positive obligation on all the stakeholders, on all of us who are the executors of this particular scheme to fulfill our role and responsibility so far as grant of compensation to the victims of accident is concerned, because unless and until we execute it to the perfection, it would be a dead letter, or it would say just lay in the book, and it all the schemes, all the words and observations will only be sort of paper tiger. And as they always say that if laws alone could have solved the problem would have been solved by now. It is the mindset, it is the role and responsibility of the concerned authorities, it is the role and responsibility of all the stakeholders that is required to be fulfilled to the hilt, because if that is not done, all the persons who are victims of these road accidents, they would not get their legitimate due. So how the evolution of this scheme had taken place, I'll just give a brief background of this. As I have already said that prior to 2009, the victims of road accidents, they were not given compensation without filing of a claim petition. So even for the purposes of filing of a claim petition, a person needs to be aware of his or her rights. Only then he or she was in a position to file the claim petition before the Motor Accident Claims Tribunal, and that too if the vehicle was validly insured. But after 2009, for the first time, Delhi High Court came to the rescue of all those persons who were not aware of their rights. And on 21st of December 2009, Delhi High Court in Rajesh Tyagi versus Jabir Singh formulated the claims agreed procedure for the first time, and it directed all the claims tribunal to dispose of the claims within 90 to 120 days with effect from 2010. So, on the basis of the observations and directions given by Honorable High Court, so far as Motor Accident Claims Tribunal in Delhi were concerned, I was fortunate that I got a roster of Motor Accident Claims Tribunal in the year 2010, and I worked from 2010 to 2012 in Motor Accident Claims Tribunal. And during that period, on the basis of directions given by Honorable Mr. Justice J.R. Midha, uh, uh, in 2010 itself, 20,820 accident cases were reported in Delhi from 2nd April 2010 to August 2012, out of which tribunal were in a position to award compensation in almost 10,000 cases within the stipulated period. So these timelines are very necessary to meet, because unless and until we meet the timelines prescribed or directed by our superior authorities, that is High Court or Supreme Court, or if a particular timeline has been prescribed by the statute, it becomes obligatory on the part of the claims tribunal to meet those timelines. And in case we are not in a position to meet those timelines, the faith which the general public or the victims of road accident who are already marginalized sections of the society, that gets eroded. So automatically the role and responsibility of the claims tribunal, it assumes importance, but I fully endorse this fact that claims tribunal is not in a position to dispose of or meet the timelines prescribed by either the High Court or Supreme Court or by the statute, unless and until we get the desired feedback, we get the desired facts from the law enforcement agencies, that is the police in this case. So while working on this particular model, which was created for the first time in 2009 and which was to be given effect from 2010, certain drawbacks, certain things were noted which were required to be modified. And Justice Midha again on 12th of December 2014 modified this claim agreed tribunal procedure after taking feedback from all the stakeholders, and thereafter this modified claims tribunal agreed procedure that was implemented. And finally the Rajesh Tyagi 3, we call it Rajesh Tyagi 3, that came into existence from 2nd April 2021. And in this particular order, what Honorable Ms. Justice J.R. Midha did and said, uh, he taking into consideration that all the role and responsibility was fixed on the police, that is the law enforcement agencies which was already overburdened. He divided the efforts which were to be put in by the police, which were to be put in by the driver of the offending vehicle, which were required to be done by the owner of the offending vehicle, or which there were certain factors, certain facts which were in exclusive knowledge of the victim, or in cases of in cases of death, the family members of the deceased. All those persons, they were called upon to provide the necessary facts within a particular period. And when all these factors were collected, the role and responsibility of the insurance company, obligation was put on the insurance company as well, that after getting all these facts, the insurance company were required to come up with a particular amount, which, if accepted by the family of the deceased, on the basis of which the claims tribunal were called upon to pass the consent award. So what I was stating earlier, that this has happened for the first time, that the observations made by Honorable Ms. Justice J.R. Midha in this Rajesh Tyagi 3 case, that was taken into consideration by the central government, and amendments were made in the Motor Vehicle Act 1988 by virtue of the 5th Amendment Act 2022, which came into force with effect from 1st of April 2022. So what has happened by virtue of this Amendment Act? By virtue of this Amendment Act, all of us, we are aware, जो इसमें पहले नो फॉल्ट लाइबिलिटी के ऊपर केसेस डिसाइड हो जाते थे, जिसमें एक स्ट्रक्चर्ड फॉर्मूला दिया गया था, that was done away with, and chapter 10 that was deleted, which was there for grant of interim compensation on the basis of no fault liability, that was entirely omitted. And so far as Chapter 11 is concerned, wherein there were sections from 145 to 164, that was totally revamped, and it was new provisions were inserted, and a new Chapter 11 was substituted in place of the earlier chapter. And this is a marvelous set of things which has taken place by virtue of this Amendment Act. The only thing is that now all the stakeholders, we are required to do our bit so that the faith and confidence in this judicial system, which was being eroded because of the delays in grant of claims to the victims of offenses, that gets back, that gets restored. So that is why I'm saying that this particular session is a very important session wherein all of us, we need to come together, we need to collaborate, we need to have a cohesive effort so that all those persons approaching the claims tribunal, or as and when any detailed accident report, first information report regarding accident is filed before the tribunal, that gets disposed of within the particular timeline. So as I was saying, that chapter 11 uh, that was inserted by virtue of this amendment. And as per section 149, the insurance company, an obligation was imposed on the insurance company because all those officers who are at present holding the motor accident claims tribunal, I'm very sure आप सब लोग डिफिकल्टी फेस कर रहे होंगे, बिकॉज इंश्योरेंस कंपनी की तरफ से कोई डेजिग्नेटेड ऑफिसर नहीं आता था जो एक अवॉर्डेड अमाउंट और एक कंसेंट अमाउंट ऑफर करता था. वो ऑफर ऑफ सेटलमेंट आती नहीं थी बिकॉज there was no designated officer appointed by the insurance company before the claims tribunal. Now a positive obligation is there that all the insurance company, they have to appoint a designated officer within 10 days. Then this 10 days is from the date of accident. Now 149(2) says that designated officer of the insurance company, he on the basis of facts which will be submitted to, मैं उसके ऊपर अभी आऊंगा, that how these facts will come into the knowledge of the insurance company. Detailed forms were annexed by Justice Midha with his judgment, and all these forms have been incorporated in the new rules which have been notified by the central government. And it is on the basis of these forms, there are 20 forms given by Justice Midha, and all these 20 forms, they were incorporated in the rules, and these are various forms which are required to be filled by all these stakeholders. Some of the forms are required to be filled by the investigating agency, some by the insurance company, some are required to be filled by the owner, driver of the vehicle. So I'm coming to that. So this designated officer who has been appointed by the insurance company, he has to make an offer for settlement to the claimant before the tribunal within 30 days. That is from the date of accident. और इसी 149(3) में again that offer when made to the complainant, it is entirely open to the complainant to accept that offer or not. If the complainant finds that the offer made by the insurance company is reasonable and he says that I accept that, then tribunal has to make the consent award within 30 days after recording the statement of settlement. So अगर complainant को लगता है, या for that matter tribunal को भी लगता है that the offer made by the designated officer of the insurance company, that is not acceptable, that is not justified, then it becomes obligatory on the part of the claims tribunal that it fixes a date of hearing and adjudicate the claims on merit. Then section 150, which has been incorporated, which is part of chapter 11, it casts a duty on the insurance company to satisfy the judgment and award against the person insured in respect of the third party risks. So whenever the claims tribunal passes award on merit, then it automatically becomes the duty of the insurance company to satisfy that award. Then section 150 says that कि अगर insured की death भी हो जाती है, so that doesn't mean that insurance company is absolved of its liability. So death of the insured shall not be a bar to claim against the insurance company. Then 158 casts a duty on the driver of the vehicle to produce the related vehicles. अब ड्राइवर के पास क्या डॉक्यूमेंट्स होंगे जो इंपॉर्टेंट होंगे, उसका अपना ड्राइविंग लाइसेंस, अगर गाड़ी की फिटनेस है तो all these documents are required to be produced by the driver of the vehicle. So it becomes his duty, statutory duty, the moment he gets the notice from the investigating officer, he has to produce all these documents. Similarly, section 158 subsection 2 imposes a duty on the owner of the vehicle to produce the relevant documents, that is registration certificate है उसका, अगर commercial vehicle है, fitness है उसकी, या उसकी इंश्योरेंस पॉलिसी है, वो सारे डॉक्यूमेंट्स ओनर को प्रोड्यूस करने हैं द मोमेंट ही गेट्स द नोटिस फ्रॉम द इन्वेस्टिगेटिंग ऑफिसर. Then section 159, it imposes a duty on the police to file accident information report before the claims tribunal within 3 months. And section 160 is there. 160 again says that it is the duty of the registering authority and the police to furnish the particulars of the vehicle involved in the accident to the victim or the claimant. तो इसमें जो ड्यूटीज है वो ड्यूटीज सारी अथॉरिटीज के ऊपर, सारे स्टेक होल्डर्स के ऊपर दैट हैज बीन इम्पोज्ड by this particular judgment as well as statutorily by amendment which have been made in the Motor Vehicle Act and which has come into existence with effect from 1st of April 2022. एक और जो इम्पोर्टेंट फीचर है इस अमेंडमेंट का, दैट इज empowering provision, empowering the central government to constitute motor vehicle accident fund. So section 164B, it empowers the central government to constitute a motor accident fund for providing compulsory insurance cover to all the road users in India. And again, 164C, it empowers the central government to make rules so far as implementation of this particular scheme is concerned. और 166(3) has introduced a period of limitation. पहले कोई limitation period नहीं होता था. So 166(3) has made that within 6 months from the occurrence of accident, application needs to be filed. And then it says that in case the award is of less than 1 lakh, then there will be no appeal by the insurance company. Insurance company is barred from filing appeal if the award passed by the tribunal is less than 1 lakh rupees. Now, as I was saying, कि इसमें रूल्स में भी सेंट्रल गवर्नमेंट ने जो अमेंडमेंट की, रूल्स जो नए नोटिफाई किए, वो रूल्स आर exactly the copy of the observations made by Justice Midha in this judgment, and all the forms, there were 20 forms which were annexed along with this judgment. They were made part and parcel of these rules. Form 1 जो है, that is the first accident report. First accident report, it has to be submitted in form 1 by investigating officers to the claim tribunal, and timeline is also prescribed. This particular form is required to be submitted within 48 hours of receipt of the information of the accident, and this form is also required to be sent to the respective legal services authority. Now, why this form needs to be sent to the legal service authority? एक चीज मैं अभी यहीं पे बता देता हूं, और उसके बाद I'll come afterwards when I'll talk to you with respect to the fast DAR. The first concept is a regular DAR, that is detailed accident report. Then Justice Midha has introduced the concept of fast DAR. I'm very sure that in the first session, Justice Midha must have spoken to you. He always used to tell a story about one of his friends जो किसी दूसरी कंट्री में रहते थे, और उनके साथ जब एक्सीडेंट हुआ and that person was in the hospital, the insurance company immediately came and paid certain amount to that person ताकि उनका ट्रीटमेंट प्रॉपर्ली हो जाए. So taking a cue from there, Justice Midha had thought that if that can happen in those other countries, why can't this happen in India? And in Delhi, we did that. We under that fast DAR, we were in a position to provide compensation involving the insurance company as well as the claims tribunal, and as legal service authority, we had constituted a special lok adalat, and the amount was awarded to the family of the deceased who died in an accident within 10 days. So on 1st of May 2021, an accident had taken place wherein one constable, Munshi Lal, working with Delhi police, he met with an accident. Unfortunately, he died at the spot. And I'm very sure that we cannot bring back the life of that constable who, while working, while on duty, he lost his life. But whatever solace we could provide to his family, that was in the form of FASDAR, that was in the form of collaborating with the investigating agency, with the insurance company, and by holding this special Lok Adalat, we were in a position to provide compensation within 10 days. And believe me, that on 12th of May, that check of the compensation amount, which was 32 lakhs, was handed over to the family of the deceased. And if this can happen in Delhi, I'm very sure that this can happen in the rest of the country as well. And we are taking the concept of that FASTDAR forward. So let me come back. So far as these forms are concerned, इस rules में जैसे amendment हुई, so initially form number 1 जो है, immediately जैसे ही accident होगा, आईओ उसकी फर्स्ट एक्सीडेंट रिपोर्ट है जिसको फार बोलते हैं, FAR, that he has to send to claims tribunal and a copy to legal services authority. Legal service authority को इसलिए ताकि legal service authority taking into consideration that whether the victim, if he is injured, or his family members in case of death, they needed to be approached. They needed to be told that you have a right to free legal assistance, and in case you want that your claim petition or your DAR should be you want to be represented through a counsel from legal assistance, immediately a counsel needs to be appointed for them who shall assist the family of the victim to get their legitimate dues. Now, why? The question is that why legal service role of legal services authority becomes paramount or important. हम सब लोग जो इस सेशन में जुड़े हुए हैं, I'm sure that either they are police officers or judicial officers or all those officers who are say presiding over the motor accident claims tribunal, insurance company. We all know that there are certain set of persons who take away a large chunk of the compensation amount which is awarded to the victims of these road accidents, and just to make sure that this whole amount of the compensation goes to the rightful person, goes to the victims. That is why what I feel is that role of the legal service authority becomes important, and all these persons, they generally come from a very weak background. They are already marginalized sections of the society, and otherwise also as per section 12 of the Legal Service Authorities Act, they are entitled for free legal aid and assistance, and we should immediately provide a legal assistance to these persons by appointing a panel lawyer, so that that panel lawyer, without charging any amount from these persons, should make sure that the entire compensation amount should go to these victims. So that is why here comes the importance and role of the Legal Services Authority. Second form जो Justice Midha ने इसमें दिया, and जो Central Motor Vehicle Act Rules 2022 में incorporate किया गया, that is right of the victims to know that they are entitled to legal aid, and about the progress of the case, that what are the different stages of the case, what is their role. So that is given in form 2, and this form 2 is to be given by the police, that is investigating officer, to the victim. वो अगर victim injured है तो उसको, अगर उसकी death case है तो उसकी family members को within 10 days of the accident. So again, this form 2 becomes very important, so that victim or the family members of the deceased should come to know that what their rights are, where they have to approach for the purposes of getting the claim or compensation. Then is the form 3. Form 3 is the we call it driver's form. ये driver को के ऊपर obligation है, which has been imposed on the driver by virtue of a statute, that is section 158, which casts an obligation on the driver कि जो उसके पास डॉक्यूमेंट्स हैं, जैसे ड्राइविंग लाइसेंस है, all those documents, all those information driver has to supply to the investigating officer. So in this form 3, driver को within 30 days of the accident, this information along with documents he has to supply it to the investigating officer. Similarly, ओनर के ऊपर जो ऑब्लिगेशन है, ओनर को वो फॉर्म 4 में अपना ऑब्लिगेशन कंप्लाई करना है, एंड अगेन विद इन 30 डेज फ्रॉम द डेट ऑफ एक्सीडेंट ओनर को ये फॉर्म 4 इन्वेस्टिगेटिंग ऑफिसर को देना है. So the whole idea was that the entire role and responsibility which was initially put on the investigating agency, police के ऊपर, we all know that police is already overburdened. They have to look after the law and order situation. They have to investigate the cases. They have to appear before the courts of law for the purposes of depositions and for the purposes of execution of various orders passed by the court. So despite that, although police were fulfilling their duties which were imposed on them by virtue of this judgment in Delhi, but to share this burden, Justice Midha had thought that we should bifurcate the roles and responsibility of various stakeholders so that the timeline within which the compensation needed to be awarded to the victims of these road accident should be met. Instead of imposing the entire obligation on one authority, he divided this role and responsibility on all the stakeholders. So that is why Form 3 and Form 4 they were created कि ड्राइवर के पास जो उसका ऑब्लिगेशन है, जो उसके पास डॉक्यूमेंट्स है, ओनर के पास जो documents which are required for the purpose of disposal of the claim petition or detailed DAR, they should be given to the investigating officer ताकि investigation getting officer उसकी timely verification करवा ले. Then comes the Form 5. Form 5 is interim accident report, IAR. Now this IAR, IO has to supply filed with the claim tribunal within 50 days of the accident. So after getting the documents from the driver as well as owner, and after doing the initial investigations at the spot, and after getting the treatment record of the injured, IO has collected certain information or certain facts, and these facts IO needs to place it before the Motor Accident Claims Tribunal within a period of 50 days as per Form 5, which has been incorporated with this judgment. Then is the Form 6A, which is the victim's form. So whatever information is required to be supplied by the victim, अगर वो खुद है और अगर वो victim कोई minor है तो फिर 6A is there. Now this particular form, these have to be supplied by the victim or family of the victim, or in case victim is minor, the guardians of the victim within 60 days of the accident to the investigating officer. Then Form 7 is DAR. This DAR, IU has to file with the claims tribunal within 90 days of the accident. So 3 mahine is the outer limit within which IO has to collect all these documents. IO has to conduct the verification of the driving license, verification of the RC, verification of fitness permit or the insurance policy from the concerned agencies, and he has to file this detailed accident report within 90 days of the date of accident. Side plan has to be part of DAR. This has to be as per Form 8. Then mechanical inspection report. So Justice Midha has taken pains and he himself had created all these forms so that IO need not run here and there where in what format I have to file the mechanical inspection report, in what format I have to file the verification report, in what format I have to file the site plan. So all the formats, all the templates, they have been prepared and now they have been made part of this Central Motor Vehicle Rules 2022. So Form 10, it talks about the verification report. Now again, this verification report has to be submitted by the investigating officer along with DAR to the claims tribunal within 90 days of the accident. Insurance form again by the officer who has been deputed by the insurance company. he has to submit this insurance form within 30 days of receipt of DAR. So the moment that DAR is filed with claims tribunal, a copy thereof has to be given to the insurance company, and within next 30 days, the officer which has been appointed by the insurance company, he needs to file this insurance form within 30 days to the claims tribunal. अब ये सारी चीजें जब claims tribunal में आ गई, then the person who has been appointed by the insurance company, he will have to submit जो मैंने आपको कहा था एक offer amount, और now it is on the claims tribunal as well as on the claimant or the victims of the road accident. If that amount is acceptable, the consent award shall be passed by the claims tribunal. Otherwise, claims tribunal shall give a date for disposal of DAR and shall dispose of the petition within a period of 1 year from the date of accident. So, अगर आप entire process को, entire system को देखें, ये forms और timelines को अगर आप साथ में हम रखते हैं, तो इन timelines को अगर हम साथ में रखते हैं, तो entire procedure, this is the flow chart. फ्लो चार्ट जैसे एक्सीडेंट होता है उसके बाद, जैसा मैंने आपको बताया, फॉर्म 1 फर्स्ट एक्सीडेंट रिपोर्ट, वो किसके पास जाना चाहिए? दिल्ली पुलिस से क्लेम्स ट्राइब्यूनल के पास भी जाना चाहिए, एक कॉपी डालसा के पास भी आनी चाहिए। डालसा मतलब स्टेट लीगल सर्विस अथॉरिटी, आपके उसमें उसके पास भी आनी चाहिए। सिमिलरली जो ड्राइवर का फॉर्म है, ओनर का फॉर्म है, वो अगेन दैट हैज टू कम टू दिल्ली पुलिस आईओ। फिर आईओ ये सारी वेरिफिकेशन करने के बाद 90 डेज के अंदर अंदर डार फाइल करेगा, उसकी एक कॉपी इंश्योरेंस कंपनी के पास जाएगी। इंश्योरेंस कंपनी अपना फॉर्म फिल करके क्लेम्स ट्राइब्यूनल में करेगी विद इन 30 डेज आफ्टर फाइलिंग ऑफ डार। सो दैट टेक्स केयर, वो हो जाते हैं 3 महीने डार फाइल करने के 90 डेज में, और 1 महीना और। उसके बाद ऑन द बेसिस ऑफ दैट, अगर वो ऑफर एक्सेप्टेबल है टू द क्लेमेंट, then consent award will be passed. Otherwise, claims tribunal shall conduct an inquiry which has to be completed within 12 months. So meaning thereby, if we follow all these timelines, and if we follow the procedure given, which we have no other option but to follow, which have been given in this judgment and now have been made a statutory obligation on all of us, तो 6 महीने से 1 साल के अंदर अंदर the person who has met with an accident or his or her family members will get their legitimate dues. And by doing this, we would be doing a great service to all those persons. And in turn, what we would be doing is restoring the faith and confidence that has been eroded because of so many reasons all of us are very well aware of. तो उस कॉन्फिडेंस को रिस्टोर करने के लिए it is very necessary, it is very imperative for all of us to fulfill our role and responsibility. अब इसमें role of different stakeholders, पुलिस का क्या role है? I've already told you, police का role है, IO have to give information to the insurance, General Insurance Council call center. So all these insurance companies, they are being supervised by a General Insurance Council, and they have created a call center. So a person shall be deputed by the insurance company, and that person would also visit the spot immediately after receipt of the information about the accident from the investigating officer. IO will collect the post-mortem report, get the vehicles mechanically inspected, collect all these reports, and then it will verify driving license and registration certificate of the offending vehicle from the transport authorities concerned, besides collecting other details. Now, एक चीज यहाँ पे जरूरी हो जाती है ये बताना कि अब देयर इज अ पॉसिबिलिटी कि वो जो ड्राइविंग लाइसेंस ड्राइवर का है, या जो ऑफेंडिंग व्हीकल है, दैट इज रजिस्टर्ड इन सम अदर स्टेट, नॉट इन द स्टेट वेयर एक्सीडेंट हैड टेकन प्लेस, या ड्राइविंग लाइसेंस ड्राइवर का है ऑफ अदर स्टेट. So a collaborative effort is being created with MORTH, or online real-time basis पे all these documents are being verified now, and all the concerned agencies are directed to assist the investigating officer, and immediately on real-time basis these documents gets verified and a report is furnished to the investigating officer so that the timelines which have been prescribed can be met. Now, what is the role and obligation of the insurance companies? Immediately on receipt of intimation, जैसा मैंने आपको कहा कि जन इंश्योरेंस कंपनी ने एक कॉल सेंटर बनाया है, उस कॉल सेंटर से immediately the information will be passed on and a person will be deputed who will carry out the investigation himself and collect the documents from the investigating officer. और वो investigation करने के बाद then after completion of the investigation by the investigating officer and filing of DAR, insurance company will come up with an offer amount. उसको अगर accept हो जाता है तो consent award pass हो जाएगा. Now what is role and responsibility of the transport authority? As I was telling that MORTH has imposed an obligation on the transport authority that immediately on receipt of request from the investigating officer, the concerned transport authority has to verify the documents which are driving license, registration document, fitness or permit, and if applicable of vehicles involved in accident within 24 hours. And they have to provide this report immediately to the investigating officer ताकि investigating officer अपना काम कर सके. Similarly, medical authorities. डेफिनेटली जितने भी यहाँ जुडिशियल ऑफिसर्स हमारे साथ जुड़े हुए हैं और प्रिजाइडिंग ऑफिसर्स ऑफ द क्लेम ट्राइब्यूनल, वी ऑल नो दैट इट बिकम्स difficult for the investigating officers at times to collect the post-mortem reports within a short period of time. And this particular thing assumes importance when I will talk about the fast DAR cases, जिसमें हम सिर्फ 10 days में हम ये चाहते हैं कि compensation amount from the date of accident within 10 days should be awarded to the family of the deceased. So medical authorities के ऊपर एक obligation है that they have to provide the post-mortem report along with the opinion as to the cause of death within a period of 48 hours from the accident. Then जहां तक मोटर एक्सीडेंट क्लेम्स ट्राइब्यूनल की बात है, on receipt of fast DAR or submission of legal offer of settlement by the insurance company, the tribunal shall hold Lok Adalat sittings in consultation with the legal services authorities, because so far as holding of Lok Adalat is concerned, it is the prerogative of the legal service authority and they shall assist the parties in arriving at a settlement. So a role of legal services authority का क्या रोल और रिस्पॉन्सिबिलिटीज हैं? डेफिनेटली इट शैल मॉनिटर एंड असेस द प्रोग्रेस ऑफ द सेलेक्टेड केसेस. जो ये सेलेक्टेड केसेस हम उनकी बात कर रहे हैं जो फास्ट डार में आएंगे. आई एम कमिंग टू दैट इन नेक्स्ट स्लाइड. लेकिन जैसा मैंने कहा कि जो फर्स्ट एक्सीडेंट रिपोर्ट है, फर्स्ट एक्सीडेंट रिपोर्ट जो इन फॉर्म 1 has to be submitted by the investigating officer within 48 hours from the time of accident. उसमें जैसे ही वो सबमिट होगी स्टेट लीगल सर्विस अथॉरिटी के पास, स्टेट लीगल सर्विस अथॉरिटी immediately shall depute a counsel who will approach the family of the victim and tell them about their rights and also of this fact that they are entitled for free legal aid and assistance, and in case they desire their matter can be pursued by the legal service authority. और आप उसमें pursue करके और you can make sure that the entire compensation amount without it being or part of it being fizzled out with the other persons, entire amount should go to the family of the victim. So immediately copy of first accident, immediately on receipt of copy of first accident report, legal service authority shall depute a counsel और वो counsel उनको assist करेगा. और इसके अलावा जो role है legal service authorities का, that is along with filing of DAR, the investigating officer is supposed to file a charge sheet so far as accident case is concerned against the driver under section 279 as and 337, 338 or 304A as the case may be. And in case the Metropolitan Magistrate who tries that particular charge sheet records conviction of the accused or the driver who has been charge sheeted, then there is a judgment which has been passed by full bench of Delhi High Court, again headed by Justice Midda, and that judgment is Karan versus State of NCT of Delhi, and this judgment was passed on 27th of November 2020, and this was to come into effect from 2nd of January 2021. As per this judgment, an obligation has been passed on the State Legal Service Authority. वो obligation क्या है कि जो convicting court है, convicting court convict से compensation दिलाने के लिए एक affidavit लेगी. Now, why this affidavit is required from the convict? This affidavit shall be of the financial capacity of the convict. Court shall ascertain the financial capacity of the convict and ask an affidavit from the convict to this particular aspect. और ये affidavit लेने के बाद court उस affidavit को legal service authority में forward कर देगी, asking to verify this affidavit as well as to submit a victim impact report. Now, what this victim impact report is? Victim impact report is a report which has to be furnished by the legal service authority stating the impact on the victim of the offense. उसके ऊपर क्या impact हुआ, वो कितने दिन ऑफिस नहीं जा सका, अगर वो स्टूडेंट था वो स्कूल नहीं अटेंड कर सका या स्कूल से उसका नाम कट गया या आगे की फर्दर स्टडीज नहीं कर सका, whether that particular accident has resulted in say permanent disability, or if that has resulted in death of the deceased, that person was the sole bread earner of his family. So what impact that particular incident has cast on the victim. So this victim impact report as well as verification of the affidavit submitted by the convict shall be submitted by the legal service authority to the concerned court within a period of 30 days. ये लीगल सर्विस अथॉरिटी का काम है एंड लीगल सर्विस अथॉरिटी विल डू, जैसे हम दिल्ली में इस चीज को कर रहे हैं ऑन रेगुलर बेसिस, एंड वी आर सबमिटिंग the victim impact report as well as verification report of the affidavit submitted by the convict within a period of 30 days before the concerned court, that is the convicting court, and it is on the basis of this victim impact report and the report regarding verification of the affidavit of the convict that the court passes the order on sentence and also passes an amount, the fine amount, out of which some of the amount is payable to the victim as compensation. So here also the role of legal service authority that assumes importance, and what Justice Midha has done, again a wonderful thing, although any judgment passed by superior courts that is binding on the Motor Accident Claims Tribunal, or for that matter any court subordinate to High Court, but Justice Midha, for the purposes of implementation of the guidelines which have been made by virtue of this judgment, he had created a committee, an implementation committee, of which myself being member secretary of Delhi State Legal Service Authority, I'm the convener of that meeting, and he directed that either the sitting High Court judge or a retired High Court judge should be appointed as chairperson of this implementation committee by the Chief Justice of Delhi High Court. So this implementation committee was constituted only for the purposes of seeing that all the guidelines which have been prescribed by this judgment by Honorable High Court should be implemented in toto by all the stakeholders. Now, as I was telling you what this fast DAR is, जितने भी अब एक्सीडेंट के केसेस हैं उनमें से कुछ केसेस ऐसे होते हैं which merely on seeing those cases we find that these cases can be settled at the earliest. Now, what these cases are, jahan aspect of Justice Midha has said that in those cases where aspect of rashness and negligence is apparent on the face of it and which is accepted by the insurance company as well. Number two, jahan driver of the offending vehicle is holding a valid driving license. Number three, जहां offending vehicle is validly insured. और एक और चीज, जहां अगर वो commercial vehicle है वहां पे valid permit और fitness है. And number five, there is no violation of the insurance policy. जैसे जो ड्राइवर था वो शराब पी के गाड़ी नहीं चला रहा था, और he was not a minor and was having valid driving license. So in all those cases where these 5 criterias are met, so as per Justice Midha, that particular case can be picked up and can be disposed of within 10 days. So this scheme is called FASTDAR scheme. So without any unnecessary delay, all those cases wherein these 5 criterias are met, जहां rashness और negligence का aspect में कोई doubt नहीं है, ड्राइवर जो है उसके पास वैलिड ड्राइविंग लाइसेंस है, ऑफेंडिंग व्हीकल वैलिडली इंश्योर्ड है, कोई वायलेशन ऑफ परमिट या फिटनेस नहीं है, और किसी भी इंश्योरेंस पॉलिसी का वायलेशन नहीं है, ड्रंकन ड्राइविंग नहीं है. सो दीज केसेस कैन बी पिक्ड, एंड ऑफ कोर्स जहां पे अगर वो डेथ केस है, ये जो फास्टडार वाली स्कीम है, इट अप्लाइज टू डेथ केस ओनली, बिकॉज इंजरी वाले केसेस में इट इज एब्सोल्युटली नॉट पॉसिबल एट टाइम्स कि 10 दिन के अंदर उसका इलाज हो जाए, कंप्लीट हो जाए. सो इनिशियली बिकॉज दिस वाज अ पायलट प्रोजेक्ट, सो दिस वाज मेड एप्लीकेबल ओनली इन डेथ केसेस, और उन डेथ केसेस में जो डिसीज्ड है उसकी जो इनकम है वो एक फिक्स्ड इनकम है, जैसे सैलरीड पर्सन है वो. तो ऐसा एक केस, this particular scheme was asked to be made implementable with effect from 1st of May 2021. All of you are very well aware of this fact that last year all of us were facing the second wave of corona, and that was a very turbulent period for all of us. But despite that, we collaborated with the insurance company, we collaborated with the investigating agency, we collaborated with Motor Accident Claims Tribunal. And after doing all these exercises, we found out first case which was dealt under this FASTDAR pilot project. And that case came into our knowledge on 1st of May 2021 itself. On that particular day, the brief facts of the case are that on 1st of May 2021 at about 3:45 a.m., that right in the night, middle of the night, a road accident had taken place. A constable of Delhi Police, Munshi Lal, he was posted at the police barricade near Vasant Vihar, and a car, Honda CRV, hit Constable Munshi Lal, which resulted into fatal injuries, and that Constable Munshi Lal unfortunately lost his life, and FIR number 78 of 2021 that was registered with police station Vasant Vihar. So the investigating officer, he intimated about that accident to the claims tribunal. As I said, that a grievance cell, a call center was constituted by General Insurance Council, and the person who was deputed from that council, he also visited the spot, and the vehicle in question that was insured with Bajaj Allianz Company. I would say that Bajaj Allianz Company in this particular case played a very vital role, and their investigator also visited the spot, and he collaborated with the investigating officer of the case. Investigating officer, he verified the driving license in the record time, insurance policy of the vehicle, and immediately the insurance company also approached the family of the victim to verify name, age, occupation, and who were the legal heirs of that victim. So then police was called upon to furnish the FASTDAR, and our authority, that is Delhi State Legal Service Authority, we provided a legal aid counsel to the family of victim, and immediately we also convened a special Lok Adalat. Pre-Lok Adalat sitting was also convened with assistance of the concerned Motor Accident Claims Tribunal, and deliberations were made on 7th of May and 8th of May, and ultimately an award of 32 lakhs that was passed on 10th of May. That is, on 1st of May, accident had taken place. On 10th of May, award was passed after pre-Lok Adalat sittings, and a check of 32 lakhs was deposited by the insurance company with the claims tribunal, and on 12th of May, that check was handed over to the family of the deceased. So this is how the FASTDAR scheme that was implemented in Delhi, and I'm very sure that we can identify such sort of cases. And Justice Mehta has also made a committee of say deciding what will be those cases or which will be those cases which can be decided under FASDAR. Definitely for having this scheme to be in place, we require assistance of the investigating officers of the police of the concerned state. Only then we would be in a position to dispose of these cases within the timeline that has been framed by virtue of this judgment and now by virtue of the Central Motor Accident Rules 2022. So I would say that in the background of large number of road accidents and death which are attributed to them, it is only just and rather necessary that a detailed and exhaustive system be formulated, which has now been done. And the duty is of all of us, all the stakeholders, that we need to collaborate, we need to come together for these poor victims of these road accidents. So, as has been said by Honorable the Supreme Court of India, that an explosive escalation of automobile accidents accounts for more deaths than most deadly disease, which has become a lethal phenomenon on Indian roads everywhere. So again, I'll implore and request all the stakeholders that all of us need to come together, need to join hands so that we can handhold all those persons who have lost their dear ones or have suffered injuries because of unfortunate accidents which takes place on the road. So thank you very much for giving me this opportunity. I'll thank Chandigarh Judicial Academy, and I wish that all of us shall work together so that all the problems suffered by the victims of road accident can be ameliorated to the best of our capabilities. Thank you very much.
Thank you, Mr. Arora. It has been such a pleasant presentation, so informative and actually making a contribution in this particular workshop. We are grateful to you and we look forward to your contributions in future also in our programs. Very kind of you to have spared time, shared the contribution with the Delhi Legal Services Authority has been making in this particular field particularly. Thank you so much. Thank you.
Thank you, sir. Thank you. Thank you. Thank you, sir. Thank you.